Hi, today we're going to talk about criminal law, chapter 4. Essentially, we're going to talk about two types of law in the United States. There's criminal law and civil law. And as you can see on the slide, there's differences from civil law that is legislative rules that govern private wrongs, whereas criminal law is offenses against society as a whole. So in the civil law, the individual is the plaintiff, but in the criminal law, the state is the plaintiff. The proof for criminal law is proof beyond a reasonable doubt, but the proof for civil law is preponderance of the evidence. And when you look at the two substantive versus procedural laws, substantive is laws defining criminal acts that are subject to punishment, regulates conduct in society, varies by jurisdiction. It's really a living document. Where procedural law is laws that are defining procedures that CJ officials, those are police, courts, prosecutors, defense, as well as the corrections, those individuals in the criminal justice system, those are the laws that they have to follow, and then rules that regulate the implementation of substantive laws. Pardon me. We talk about criminal law as a political phenomenon. All I mean by that is just that human beings regulate the behavior of other human beings, so that just to know that what we have as law today might change. So a good example of that is the use of medicinal versus legal marijuana, and that probably 15 years ago, people would have never thought that medicinal marijuana would have been legal, and now we have medicinal as well as recreational marijuana that's legal in certain states. So just know that at some points laws can change. The idea about abortion at some point being illegal and now being legal in the United States, and who knows what the future holds for that could possibly change as well. When we look at creating laws in the United States, criminal laws in the United States created by legislative bodies, they're affected by common law or case law, and then they're interpreted by courts or administrative or regulatory agency decisions. What I mean by that is that constitutions and legislative bodies, we look at Congress enacts federal statutes, state legislatures enact state statutes, municipalities such as your city enact laws that are generally called ordinances, and so at every level of, when we look at really global things as far as down to more micro manageable types of things, that we have legislative bodies for that. Four sources of criminal law are constitutions and penal codes. Within penal codes are states, statutes, and ordinances, and then we have administrative regulations as well as precedents. Common law, also called case law, is a product of decisions made by trial and appellate court judges who produce case law whenever they render decision in a particular case. They call it precedent, and all a precedent means is just a decision that forms a potential basis for deciding the outcomes of similar cases in the future. So the operative word there is similar cases, and so you might have heard of precedents or stare decisis, and that's just simply saying that it's been upheld in other courts similarly, and so the current court that you're arguing against in front of might consider that as precedent. And so again, the principle of stare decisis is just that there's been a legal precedent for it, and then the interdependency among sources of legal authority. So although federal and state criminal statutes are essentially independent of one another, provisions of the Constitution always take precedence over state statute. So I'm going to repeat that because it's really important that the provisions of the Constitution, so that is at the highest level of decision making, so the U.S. Supreme Court, which enacts law for the entire United States, that always will take precedence over the state statute. Now, interestingly enough, if the state statutes don't have any law, if the federal statutes don't have any law, then they'll listen to the state statute. But if there is a federal statute that is in opposition to the state statute, they will listen to the federal statute. That will be the law that stands. So rights of the accused, most of the procedural rights given to criminal suspects or defendants are found in the Bill of Rights. Others are found in federal and state statutes, state constitutions, and then criminal procedure. It's important for me that you understand the difference of the Bill of Rights, that the Congress quickly, after they created the Constitution, they proposed a set of 12 amendments, 10 which were ratified by the states and became known as the Bill of Rights. And if you look on Table 4.2, it's really important for me that you understand the differences of what the procedural rights are and what particular amendment is related to. This will be important not just for this class, but for other criminal justice classes if you happen to take them. I'm not going to talk about each Bill of Rights, but I will talk about some of the important different amendments. So the 14th Amendment was ratified in 1868, and it really is saying that selective incorporation of the Bill of Rights, that before the passage, the Bill of Rights only applied to certain people charged with federal crimes, and the 60s by the Supreme Court headed by Chief Justice Earl Warren, which has been a very liberal court, left-leaning court, began making the procedural safeguards of the Bill of Rights. And so the 14th Amendment over time has been able to suggest that, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens, nor shall any state deprive any person of life, liberty, or property without due process. So 14th is about due process. And we talk about arrest. This is the seizure of a person or the taking of a person into custody and making sure that people feel comfortable knowing what is that you've been handcuffed, that the police officer said that you are in fact under arrest. This is orally. This is in statement that's oral, so the police officer says you are under arrest, and then they physically detain your ability to leave. Reasonable suspicion and frisk. This is the concept that you might have seen in the news, the stop and frisk. Reasonable suspicion is just a standard of proof that's more than a gut feeling. The ability to articulate reasons for the suspicion, and then the frisk part, that's the action part, is conducting a search for weapons by lightly patting the individual's clothing or feeling for hard objects that might be a weapon. And then probable cause for this is that the amount of proof necessary for a reasonably intelligent, and that's the operative word, is reasonably intelligent person to suspect that a crime has been committed, or that items connected with criminal activity can be found in a particular place. And then standard of proof is the line between probable cause and reasonable suspicion. So we have probable cause, standard of proof, reasonable suspicion. And then this is just to determine whether standard proof has been met. And then when you look at preponderance of the evidence, this is just simply saying that the evidence outweighs the opposing evidence or sufficient evidence to overcome doubt or speculation. And this is the standard of proof required in civil lawsuits. So you'll see up above in that table that I have that the preponderance of evidence does suggest that it just has to overcome just a little bit about the doubt or speculation. So clearly in a criminal case, the guilty evidence is much more severe. So clear and convincing evidence that indicates that whatever is to be proved is highly probable or reasonably certain. This is also in a civil case. And then, like I just said, beyond a reasonable doubt, this is in a criminal trial. So we're looking at different standards of proof. Proof evident, presumption great, burden is on the prosecution. So when you have a case against the state, it is up to the prosecution that is going to prove that case. So your public defender, your defense attorney, however, whomever's on your for the other side, it is not up to them. It is the evidence of proof is on the prosecution. So they have to bring a case forward, and they have to be able to establish evidence. The exclusionary rule is really important. This was created in 1914 and looked to the states in 1961, and this just says that the legally seized evidence must be excluded from trials in federal courts. And so, importantly, for you to know, the exclusionary rule originally had three purposes. Number one, to protect individual rights from police misconduct, and so we'll talk a little bit about the forbidden fruit. Number two, the other part of the reason for the exclusionary rule is to prevent police misconduct, and then number three is to maintain judicial integrity. And so in talking about the exclusionary rule, we have the good faith exception. It states that as long as the police act in good faith when they request a warrant, that the evidence they collect may be used in court, even if the warrant is illegal or defective. And then we also have the other part of the really caveat to the exclusionary rule is the inevitable discovery states that if the evidence obtained illegally can be used at trial if the information inevitably would have been discovered by lawful means. So that means that if you get stopped by a police officer and you have drug paraphernalia in open sight and it would have been discovered anyhow, even if it was an illegal search, the police still can say that it was inevitable discovery and to suggest that it should be admitted into court. But just know that the exclusionary rule really was to try and make sure that police are doing their job and the judiciary are doing their job. And then they came back behind that and said, well, making sure that there's not exceptions even to the exclusionary rule. The Patriot Act was given broader powers to the FBI, CIA, and other foreign intelligence to spy on American citizens. So this was in your lifetime. This law eliminates checks and balances on those powers, such as judicial oversight, public accountability, and the ability to challenge government searches in court. Under the Act, the FBI no longer needs probable cause to conduct wiretaps. That's really important. That's really their one broader definition, is that they were able to conduct wiretaps of criminal suspects when, quote unquote, a significant purpose in gathering the intelligence. So if police today believe that you were potentially plotting against the United States and they believe that you were a domestic terrorist, then they could use the USA Patriot Act to say that they could wiretap your phone to see if they could elicit information that would be able to be used in a court or to issue a warrant against you. So, when we're talking about different types of Bill of Rights, we talk about protection against compelled self-incrimination. So the Fifth Amendment is the protection against this, and this is really based on the belief that confessions made involuntarily may not be truthful. I'm going to repeat that. Confessions made involuntarily might not be truthful. Really just simply saying that if the police pick you up and they coerce you, they might deny you your ability to see your family. They might tell you it's no big deal. You don't have to see an attorney. So the Fifth Amendment is just simply saying self-incrimination, you don't have to. And so the doctrine of fundamental fairness is that the rule that makes confessions inadmissible in court if they were obtained by means either psychologically, manipulation, or third-degree methods. Now, I'll be honest with you, this all sounds phenomenal and great. The idea of us actually applying that is really difficult to know whether or not the police, whom there is a definition, there is a legal ability for them to coerce to be able to get access to the information. Does it rise to the level of Fifth Amendment right? So it's often very difficult to be able to prove that. And so Miranda versus Arizona in 1966 said that, in fact, that we need to tell people, we need to specifically tell people that when they're A, under arrest, and then B, when they're being taken in, that they can't or shouldn't use, they have a protection in the Fifth Amendment for their ability to not have to say anything. And so the Miranda versus Arizona, it's called, your Miranda rights, and that they must be notified of their specific rights or confessions will not be admissible. So anytime that you are put under arrest, you need to, at a certain point, be Mirandized. And if you're not, then we can throw that evidence out. So the Miranda ruling guaranteed that the suspect could be warned prior to the questioning that they have the right to remain silent. Anything they say can be used against them in a court of law, the right to the presence of an attorney, and then the last one is if they can't afford an attorney, one will be appointed to them. And so just being able to tell them that they don't have to incriminate themselves. So the Fifth Amendment further applies to trial procedures. That a defendant does not have to answer any questions put to him during the prosecution, during a trial, because remember, it is the onus is on the prosecution. They have to prove the case, not the defendant. And the defendant doesn't have to take the witness stand, and the prosecutor is forbidden from commenting on the defendant's silence. So the Fifth Amendment covers that as well. The Sixth Amendment is about the ability to speedy and public trial. It has to be by an impartial jury. They have to be informed of the nature and cause of the accusation, to be confronted by witnesses against them, and to have compulsory process for obtaining witnesses in their favor. And then last, to have the assistance of counsel for defense. And so, there's a long history about the Sixth Amendment, and the right to be informed of the nature and cause of the accusation. So you if you're coming into court, there has to be somebody that you had to have had the right to notice in a hearing is the very core of what we're talking about due process. And this right prevents the practice from holding suspects indefinitely without telling them why they're being held. So we need to articulate to why you were being under arrest under the Sixth Amendment. Right to confront witnesses, opposing witnesses, that the defendants have the right to be present during their trials, and then secondly, that they get to cross-examine them. So, for example, if somebody is saying something about your character, if you so choose, then you could be able to cross-examine them. However, just know that if you choose to cross-examine someone else, then you yourself can be cross-examined. But under this amendment, you don't have to be able to, under the Fifth Amendment, you don't have to be able to self-incriminate. So right to compulsory process for obtaining favorable witnesses. And this is just simply saying that the defendants have the right to use subpoena power. What's a subpoena? It's a written order issued by a court that requires a person to appear at a certain time. If you are subpoenaed and you don't show up, some jurisdictions, depending on how busy they are, but they could then issue a warrant for your arrest. And so you might not even know a warrant for your arrest is out until maybe you get stopped by a traffic stop, and then that traffic stop, you get stopped, and then the police officer says, oh, you have a warrant for your arrest. And you say, what? I didn't know. And it's because perhaps that you were subpoenaed to come to court. I'll just tell you this, apart from these PowerPoints, that the court does not like you messing with it. So if the court tells you to appear, I'm going to plead for you to please appear. An FTA, which is called a failure to appear, seems so benign by most, but the courts do not look favorably on an FTA. So if you fail to appear in the courts, it's absolutely going to impact you later on. So make sure that if you're ever called to court for whether it's traffic, civil, criminal, you always show up. Even right now, as we stand right now, and maybe you've forgotten that you had an outstanding ticket in Florida, if you get stopped in North Carolina, the way that the computers work now, they could still say, oh, well, you have a warrant outstanding for your arrest in Florida, and so they could arrest you in Charlotte and then extradite you if they so choose. I highly doubt that they would, but I'm just saying FTAs are not something for you, not something that you want on your record. So we would look at the right to counsel. The right to hire a private attorney did not exist until 1954. So even though federal courts who could not afford them up until 1938, the Supreme Court said, sure, we can afford one as long as you were facing a felony. So that's the operative word there, is that in 1938, as long as you were facing a felony. Up until then, and then you'll see, like, as over time, then the Sixth Amendment also guarantees the right to effective counsel, and the counsel's performance has to have been proven deficient, or those deficiencies in the attorney's performance were prejudicial to the defense. So if that happens, then you could potentially get a new trial. If, for example, your attorney was drunk, or your attorney didn't have any objection when it was obvious that they should have objected. So any of those reasons, we could say that that's why, a good reason to say that why you should, in this amendment, for you to be able to say, oh, well, that was against my rights. The Eighth Amendment is excessive bail. The thing about excessive bail is really important on this side, is that the Eighth Amendment doesn't require that bail be granted. So it's really important for me that you know that. It doesn't mean that you get bail. That's not a guarantee. What it does mean, though, is that it can't be excessive. So if you're given the opportunity for bail, it means that you can't be excessive. That's all that this means. Is so the protection against excessive bail and fines, that the nature and circumstances of the offense. So if somebody else in a similar situation, what would they have gotten? The weight of the evidence, what would happen to them? The character of the suspect, what would have happened to a reasonable person in another place or another time? So, and then the ability of the suspect or defendant to pay bail. So what happens is you can't say, oh, well, you're a drug kingpin and you have lots of access to cash. And so because you have that, we're going to set your bail really, 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 really high in the hopes that you can't get out. Well, that's not protected under the Eighth Amendment. You can't be excessive. So if you believe that that drug kingpin has a if you can prove to the judge that's listening to the bail, and you can say, well, if this drug kingpin gets out, then they're going to go kill somebody, or they're going to go harm somebody. Well, then the judge will look at that and say, well, should I deny bail or not? But just know that the Eighth Amendment is all about excessive bail, not whether or not you should have bail, but it's really about excessive bail. All right, so protection against cruel and unusual punishment. So for 120 years after the adoption of the Bill of Rights, the Supreme Court interpreted cruel and unusual punishments based on practices that were authorized under the amendment in 1791. Punishments that were prohibited involved torture, unnecessary cruelty, and lingering death. Well, that's different now, right? So now the Supreme Court determined that the meaning of the Eighth Amendment is not restricted to the intent of the framers of the Constitution. The Eighth Amendment actually bars punishments that are excessive. What is excessive is not fixed in time, but changes with evolving social conditions. So a lot of times people will say that the death penalty is cruel and unusual. And so it really has to determine whether or not the way that you are put to death, is it truly cruel and unusual? And most states, as well as the Supreme Court, have held that the death penalty is not cruel and unusual. So beyond the Bill of Rights, a general legal definition of a crime, it has to have these 5 things. It has to be a legal wrong. It has to previously been prohibited by the criminal law. It has to be prosecuted by the state. That's your prosecutor. It has to be in a formal setting, so a court setting, and then it has to be a criminal sanction or sentence may be imposed. So that last part, in which a criminal sanction or sentence may be imposed, is critical. It could be legal wrong, it could be prosecuted, it could be prohibited, but is there a sanction? So do you, when you go to court, has it already been established what's the sanction for that crime? And these 7 elements of a crime: legality, actus reus, causation, harm, concurrence, mens rea, and punishment. For a behavior to be defined as a criminal and subject to legal penalties, the prosecutor must prove that all 7 have been fulfilled. So the first one is the legality. The law must define as a specific action as a crime. The law must be defined before the action occurs. So if it's a new crime, and somebody's going to say, oh, well, let's go ahead and set this up, it can't be ex parte, it can't be after the fact. So if it's a new crime, they have to let it go what you're in court for today, and then say, well, in the future you can't do it anymore. Another element of the crime is actus reus. This is the guilty thought, the guilty act. So in some instances, speech can constitute a crime even though there's no specific physical action. So that's yelling fire in a theater is highly illegal and would be the guilty act, the actus reus. The harm: to be a crime, an act must cause harm to a person, property, or object that a legislature has deemed valuable, and that's pretty widely defined. Causation: so there must be a causal relationship between A and B. So, something like for you to get pregnant, you actually have to have sex. So there has to be a clear link between the crime and harm. So that person wouldn't have died unless you held them up. So sometimes there is causation even when you go in and you hold up a store and the clerk happens to be elderly, they have a weak heart, and they end up dying, and you're like, well, I didn't intend for them to die. However, your causal relationship, had you not held them up, they wouldn't have died. They'll get you on this part, causation. Mens rea is the guilty mind. So it's not necessarily the commission of an act is not a crime unless it's accompanied by the intent to inflict harm. So the criminal intent is the intent to commit a crime based on the assumption that people have the ability to make reasonable decisions. And so this is also coming in on our behind our definition of theory and being able to make learning theory and that sort of stuff. Another definition, another element of a crime occurring is concurrence. So that means, this is important for you, the concurrence means the actus reus as well as the mens rea must be present at the same time if a crime is to occur. So the guilty mind and the guilty act has to be together. Punishment is just, again, that it has to be written down. Without the punishment, it's unenforceable. And so this is just the difference between a felony and misdemeanor. This is also talked about in Chapter 1, but just know that your felony offenses are more serious. They're punishable by death or imprisonment more than a year in prison. And then your misdemeanor less serious than your felony, punishable by incarceration for less than a year, or sometimes it's up to 2 years in a jail. And then beyond, the misdemeanor, beyond lower than that are going to be your citations and things like that. Your felony misdemeanor comparison is just that the classification has to determines on what you were arrested for. So your police officer will be able to determine, okay, I'm picking you up for this, I'm giving you Mirandized rights for this, and I know that I'm going to charge it as I'm going to try and write it as a felony or a misdemeanor. And of course, it's up to your prosecutor, which we'll talk about later in the class, to be able to determine how they're going to charge you. So mala in se versus mala prohibita. Mala in se is natural law, laws that are regarded by all other people to be wrong in themselves, or murder, burglary, and arson. So no matter where you are, people would say that mala in se is that, well, that's pretty much what we all think of for crime. Mala prohibita is that it's considered wrong only because there's a law against it. So these are moral offenses. Gambling, some people don't think gambling, and in fact, in certain states, gambling's not illegal. Drug use, again, in certain states, it's no longer illegal. Driving too fast, in certain countries, it's not illegal. And then prostitution, underage drinking. So mala prohibita is just, it's wrong because there's a law against it. What mala in se is, nobody would argue about the severity of those types of cases. And then when we look at criminal defenses, deny the actus reus, claim that the act was justifiably committed, and claim that the act was done, but there was no criminal intent. And we look at 4 different reasons where we could be able to negate the intent. And so insanity, intoxication, age, and mistake. When we look at insanity, essentially that it's a legal defense to determine if a person's state of mental balance negates. So that is saying that they didn't know what was happening for the criminal responsibility. They could say, well, I'm insane. I didn't know that I was murdering my girlfriend when I was high on drugs, I was insane, or I went into my high school and I was temporarily insanity, and so that's when I shot all my peers. So just know that insanity is a legal term, it's not a medical term. And types of insanity defenses are the McNaughton rule, the irresistible impulse, the Durham, and the substantial capacity. And so you'll look in the book to determine where is North Carolina as far as which of their various legal defenses standards for their be able to say that, use that as a defense to say, oh, well, I didn't know because I was insane. Another one is intoxication. So this is interesting for college students to know that not considered a viable defense unless the person becomes involuntarily intoxicated. So what that means is just that the individual was given Rohypnol or date rape drug or something like that while under duress, and this may lessen the degree of seriousness for voluntary intoxication. Age is another defense that children under 7 are deemed not to form consent of intent, and then under 7 and then below the age of 18, an individual is typically charged as a juvenile, and then after the age of 18 in most states, I think in North Carolina it's 16, but they're looking to raise it to 17 if they haven't already, for the age of emancipation to be an adult, to be able to not claim age as a defense. Other criminal defenses: consent, self-defense, entrapment, double jeopardy, mistake, or duress. So consent is just that the type of crime dictates if this is a valid defense. Is the victim capable? So is the victim of high cognition that they could actually give consent? Did the offense must be a consentable crime? Did the consent not be provided through fraud? And then the person giving consent must also have the authority to do so. And then self-defense is the behavior legally justified by necessity to protect their own life or property from another. The defendant didn't provoke attack. The attack was imminent. Use of force was a last defense, and this is the self-defense, or only amount of force required to repel the attack. And then entrapment is another legal defense, and this is just simply saying that the government caused an otherwise innocent person to commit a crime. So used when law enforcement agents use traps, decoys, or deceptions to include criminal actions. And then double jeopardy is no person shall be subject for the same offense to be twice. So if at one point you had gotten free and clear, a prosecution can't come behind and say, oh, I'm going to retry you. It prohibits the reprosecution of the defendants for the same offense. Now, that doesn't mean that the prosecution can't potentially charge you for a different offense, but the same offense by the same jurisdiction. And then mistake, duress, and necessity. And so this is just simply saying, oh, well, gosh, I didn't know it was yours. It was an honest mistake, or a mistake of the law. Gosh, I didn't know. And, you go to a different country, you don't know the speed limit. You go to a different state, you don't know their laws. ignorance of the law is not a valid defense, so this is not something that the laws would look at kindly or duress, and to say that you were forced into committing a crime, that really has to have a pretty high level to be able to determine that that was a viable defense for why you did what you did. And the necessity is that harm avoided must be greater than the harm that your offense was charged for. And so that's chapter 4, the legal part in a nutshell. What I would like you to do is make sure that you understand the difference between civil and criminal. I want to make sure that you understand the Bill of Rights, and I want to make sure that you understand the different defenses, and then what is a felony versus a misdemeanor.